Wow, today in court with Vince Davis was mind-blowing. I can't even put into words. I wish he could be videotaped so you could see this genius man.
Good morning. Good morning. This is Attorney Vince Davis, and these are my office hours. I hope those of you that are watching can post questions, because maybe I can take some Q&A at the end of the presentation this morning. Welcome back to the CPS office hours. I'm Attorney Vince Davis, and today we're talking about a critical moment in every CPS case, the detention hearing. It's the absolute number one first hearing that you'll attend in the juvenile dependency court in the Superior Court of California. I know in other states they call the detention hearing by a different name, but here in California we call it the detention hearing. Whatever it is called in your state, it doesn't matter. It's the very first hearing you go to in a CPS case. If you're a parent or relative whose child has just been taken by CPS, this hearing will happen fast, often within 72 hours, and it will set the tone for the entire case. Today, I'll walk you through what happens, what to expect, and how to prepare. If you're watching and this content is helpful, please consider donating to support our mission. Your donations help us keep producing these resources, educating parents, and reuniting families. What is a CPS detention hearing? Well, let's start with the basics. The detention hearing is usually the first court appearance after CPS removes your child. In California, it typically happens within 48 to 72 hours of the child being taken from the home. At this hearing, the judge decides whether your child will stay in CPS custody or return home while the case proceeds. Their hearing in short, this hearing is short. It may also last 15 to 30 minutes, but the impact can last for months or even years. That's why you need to be prepared for the detention hearing. Many times people just show up at the detention hearing not knowing what's going to go on. They get assigned an attorney, and then shortly thereafter they do their hearing. The next question becomes, who's going to be in the room, in the courtroom itself, when you do the detention hearing? This is extremely important that you know the audience that's going to be there, because it may affect what you do, what you say, how you look, and how you interact with your attorney. In the courtroom, usually you will see the judge, a CPS attorney. In California, we call them the county counsel, the CPS social worker. In Los Angeles, the worker usually doesn't show up, but there is an in-court officer, CPS worker, who they call, who takes the place of the real social worker on the case. But in some counties, like in San Diego County, the actual social worker shows up for the CPS hearing. Also in the courtroom will be your attorney, court-appointed or privately hired, a lawyer for your child, sometimes the other parent's attorney, and of course, I mentioned that the CPS attorney, the county counsel. This is not a private meeting. Everything you say is on the record, so be calm, be respectful, and do not interrupt anyone while they are talking. Next, let's consider what the judge is looking for in these detention hearings. The judge is asking one major question. Is it safe for the child to return home right now? The judge will look at the CPS report, including the allegations of abuse or neglect. The judge will look at any reports or the extent of police involvement. The judge will look at the risk to the child if returned home. The judge will look at the burdens of the child not returning home. Sometimes children are so emotionally distraught that they're removed from their parents. And the judge will also consider your CPS history, if you have one, or your criminal history, if you have one. At the hearing, the judge can, 1, return the child home, 2, keep the child in foster care or with a relative placement, and the judge can order, if the child isn't returned, order you to have supervised visitation. This is not the trial, it's just about temporary placement, but it often influences the whole case. One of the things that I want you to be concerned about or watch out for is if the child is detained and you have monitored or supervised visits. A lot of times the social worker will set up a situation where you can't have your visitation unless you talk to the social worker. And if you have me as an attorney, I don't want you to talk to the social worker without me being present on the phone or in person. So don't get bullied or tricked into talking to social workers so that you get your visitation. If any condition is put on you for your visitation, you need to let your attorney know immediately. So the next question is, how do you prepare for your detention hearing? Here are some of the ways that I prepare and I tell my clients to prepare. First, you got to hire or talk to an attorney immediately. 2, bring support people to court. They will quietly sit in the gallery and may or may not be permitted to be in the courtroom. A few weeks ago, I did a case where there were family and friends who came to support the family. There were 81 people, according to the sheriff, who was there, who came to court to help support the family. The judge and or the bailiff only allowed 13 members of the family and friends into court. And I think that was more of a space requirement, more of a space limitation. The other 81 knew that the other people, relatives and family and friends, knew that they probably wouldn't come into court, but their support was duly noted by the judge. At this hearing, you got to have some evidence and some proof ready. Clean drug tests, school reports, medical reports, and talk to your attorney how to get those into evidence at this detention hearing. If you come empty-handed, that means you have no evidence, and that means the social worker will probably win. So show up to court with some evidence. Next thing is create a written statement or letter for your attorney to present, or to at least read and make certain points regarding their argument in trying to get the child released to you at that day. Now, one of the most important things is at that first hearing, if the child isn't going to be returned to you, ask for relative placement. And by relative, I mean family, friends, or actual blood relatives, relatives by marriage. Okay, part of the reason and the strategy of having 81 people at the detention hearing was to say to the judge, hey, judge, if you don't release, I got 80 people outside that can take the child or take the children. Social workers may be hard pressed when they say, well, we don't want the child released to this relative or that relative. But 81 people, I don't think that the judge is going to accept that type of explanation. By the way, in that case that I did, the social workers had the opportunity to release the child 2 or 3 days before to relatives, and it was 3 children. Instead, they chose to keep the children in foster care in a strange home. And although the judge didn't say it, I got the impression from his facial and body language that he was a little disturbed that the social workers wouldn't place the children with family or family friends, and there's 81 people sitting outside of his courtroom. So bringing those people to court does have an impact, all right? And as a matter of fact, The judge released the child or the children back to the mother, my client, but he did require one thing. He required two of the relatives who were going to be considered as placement for the children to live with my client temporarily. And the relatives were happy to do it. One was the actual grandmother and the actual aunt. They lived together anyway, but they moved into the family home to help keep the children in the home and help the mother with the children temporarily. And boy, that's better than keeping the children in foster care. Also, I want you to remember this. Don't argue with the social worker in court. Keep your emotions and your statements in check. And if you're well prepared with your attorney, go ahead and let your attorney do all of the talking. You should only respond if the judge asks you a question. All right? Otherwise, let your attorney do the talking and the arguing. The next thing that I want you to know that happens is after the hearing, if your child remains detained, CPS will create a case plan, and the next hearing will be the jurisdictional hearing. That's where you can fight the truth or falsity of the allegations. But the detention hearing is your first chance to show the judge you're serious, organized, and ready to parent safely. One of the things that you have to realize that the judge usually sits elevated above everyone else in the courtroom. There's a symbolic meaning to that, and there's also a practical meaning for it. During the hearing, if you're seated at the judge's bench, and you look out into the audience and you look out to the counsel table where the attorney and or the parent are sitting, the judge can glean and get a feeling for you as a parent, just like you would do if you were a human being looking out into the audience. So make sure that you're dressed appropriately. I have something called the court uniform that's specifically designed to get the most benefit out of your appearance when you're in the courtroom. Maybe one day I'll do a show about the court uniform and how important it is. All right. The detention hearing can feel overwhelming, but it's also critical. It's a critical opportunity for you. Come prepared, stay calm, and let your attorney do the talking. If you need help preparing, I invite you to join my Fight CPS School, SKOOL. It's just $10 a month and gives you weekly guidance and live webinars, and you're able to download templates to use in these CPS cases. Also, please consider donating to our channel. Every live stream we do is made possible by people like you. Your support helps us to reach more families and keep this legal information free to those who need it most. All right, let's take some questions and answers. Let's see. Oh, I have a lot of new viewers today. Okay, from YouTube, Justice. I can't pronounce the last name there, but Justice says, I wish deeply I would have found you then. My child would be here with me. Thank you for immense patience and compassion and care to explain all of this to us. Thank you. You have been there letting us all know about this. We appreciate much you do for all. We are thankful for caring. Thank you. Well, I appreciate those kind words, Justice. But do you have any questions for me to ask or to ask of me? And I know that we have several people watching on Facebook and YouTube. If you have any questions, shoot me a question. I'll be happy to answer it. Also, I want to say there's a PDF that goes along with this presentation. It's just a small little checklist that you can use to have or to look at your preparing for your detention hearing. And it's called the CPS detention hearing checklist. I'm going to have the producer, Grace, go ahead and upload this to Facebook and YouTube. And when she gets on, she comes on at 8 a.m. Pacific. So check back and see if you find the download, and you can download the, right from where you watched the presentation this morning. And if you're going to be watching this taped in the future, maybe later on today or next week or wherever, you will see that there is an attachment, a download that you can download and print out for your for your records. Okay. All right. It doesn't look like we have any other questions this morning. Justice, I appreciate your appreciation. Do you have any questions for me that you want to post? If not, I'm going to end the office hours this morning. And everyone, have a good day. And we'll see you tomorrow at 6:30. Come with some questions. I love to take questions from the audience. Have a good day and stay safe. Bye-bye.
With this amazing God-given brain and talent, he outsmarted everybody, and he's still going. And I am so excited and I have so much faith and peace that we are going to win. It's coming.